Finally, we have covered both the parts of chapter 17, the charge, form of charges and joinder of charges, with section 223 and 224, which we are going to cover right now. Part 1, form of charges, section 211 to section 217 we have already covered. Don't get bored, we are revising it so that you don't forget any sections. And part 2, joinder of charges, we have already covered from section 218 to section 222. Now we are gonna cover section 223, and the key word to remember section 223 is jointly. It has got 7 parts. Let's check what they are. Before I start, let me tell you the most important part of this lecture. In joinder of charges, from section 218 to section 222, if you check properly, it is joinder of cause of action. But this section, section 223, the only section, is regarding joinder of persons. So there is a difference between the two, which every law student must know. This has confused a lot of people in mains judicial examination. Section 223. The keyword to remember is jointly, because it's about joinder of persons. It is further divided into 7 parts from A to G. Let's check what they are. Section 223. It says what persons may be charged jointly, and it further informs us in 7 parts. A says persons accused of the same offense committed in the course of the same transaction. This means all the persons jointly may be trying different things, but their aim is the same. B says person accused of an offense and person accused of abatement of or attempt to commit such offense. Now all the person will be tied with one rope. You remember this quote? Why it is said? Because of this thing. The person who has committed the offense will be tried together with those people who were abetting such offense, means asking them to do such offense, and also all those people who even tried to do the offense but may not be successful, or they may not be completing it, but the other person has completed the offense. So all these people will be tried together. Third thing it says, C part, person accused of more than one offense of the same kind, within the meaning of section 219, committed by them jointly within the period of 12 months. Means all those people will be tried together even if they have committed the offense after a huge gap, but within the period of 12 months. Fourth, D part. It says person accused of different offenses committed in the course of the same transaction. So people might be doing different things, but it is the same transaction. They will be tried together. Now what does it mean? One of the person might be breaking the lock of the car, and the other person drove the car in order to take away the car by stealing it. So the person A cannot claim that I just broke the lock of the car, it was my friend who drove it and stole it away. No, they both will be charged together because it's the same course of transaction. They might have committed different things. I hope the D point is clear now. Next, E part. Person accused of an offense which includes theft, extortion, cheating, or criminal misappropriation, and person accused of receiving or retaining or assisting in the disposal or concealing of property possession of which is alleged to have been transferred by such offense committed by the first named person, or of abatement or attempting to commit any such last named offense. Don't get confused, this is very easy. A person might steal something very important, confidential. They try to extort money for giving that document back. They might do the cheating as well, or even do criminal misappropriation of property. And in doing so, they might take the help of other people for keeping such things, hiding such things, and concealing it from other people. See, it becomes a chain of offense when one person helps the other in either committing the offense or trying to hide that they have committed such offense. And there might be another person who is abetting it. Okay, come on, do it, man. No problem. We'll get rich. All such people will be tried together. F part says, person accused of offenses under section 411 and 414 of IPC. See, it's very easy to remember. 411, 414 of IPC. Or either of those sections in respect of stolen property, the possession of which has been transferred by one offense. So it simply informs us that if the person is accused under section 411 and the other is accused under section 414, both of them will be tried together in respect of the same property which was transferred by one person to another. Or if the accused is charged under section 411 and 414 both together. So in both the cases, they will be tried jointly. G part, person accused of any offense under chapter 12 of Indian Penal Code relating to counterfeit coin and person accused of any other offense under the chapter relating to the same coin or abatement of or attempting to commit any such offense, and the provisions contained in the former part of this chapter shall so far as may be applicable to all such charges. So it's basically, you can say, relating to counterfeit coin, person who is possessing it, person who tried to trade it, person who abetted about it, that okay, we will sell this counterfeit coin to be real to other person, person who might be abetting it to do it, all person will be charged together as given under the chapter 12 of IPC. Now there is a condition to it, provided that where a number of persons are charged with separate offenses and such persons do not fall within any of the categories specified in this section, then in such case either the magistrate or the session court, as the case may be, may, if such persons by an application in writing so desire. Now over here it doesn't mean that they have desired and they will be allowed. It is the discretion of the magistrate or the session court. If they are satisfied, then that such persons would not be prejudicially affected thereby, and it is expedient so to do, try all such persons together. It's clearly informing us that sometimes some of the person are charged differently, which does not fall in this category, means in this section 223. They may be charged entirely different things, but when they are tried together, they can make an application to the magistrate or the session court that they should not be tried together because the charges are entirely different. But if in case magistrate or the judicial or the court of session thinks that it doesn't matter, they can be charged together, then definitely they will be charged together and they will be tried together. Now let's cover a very important case, Trilokchand versus Rex, AIR 1949 ALL 187. This is important because it's informing a very important thing. Under this section, which means under section 223, joint trial of several persons is permissible. Yes, we have just covered it, but it informs us that this section applies only to trials and not to the inquiries. Got the point? Supreme Court further says, a joint trial of several persons under this section is not violated merely by the facts that at the end of the trial the facts found happens to be different from those on the basis of which the charges were originally framed. See what happens, sometimes the persons are charged together, but facts are found to be different from some of the persons who were joined with the other persons. That does not mean it is going to affect the case completely. It does not violate at all. Got it? Okay. Let's cover one case. Qadri Kunahmad, I hope I'm pronouncing well, versus State of Madras, AIR 1949 ALL 187. In this case, A and B were jointly tried. 5 different charges were framed against A. 3 charges were related to offenses committed by him as principal and 1 as an abettor. And 5th one was conspiracy with B. So I hope you understand that they are all different charges. The principal charge was for conspiracy under section 120B read with section 409 of IPC 1860. Now he can take a plea that I cannot be charged together. They are different charges. No, the Supreme Court held that joint trial of the accused was permissible under clause D of this section. Clause D of this section means clause D of section 223 in view of the charge of criminal conspiracy. Now write down in the comment what is clause D of section 223 so that you remember clause D of section 223 whenever anyone asks. Finally, after covering all 7 parts of section 223, now we remember its joinder of persons. Now we come to the last remaining section. The keyword to remember is the remains. Section 224. Let's check it right now. Section 224. Withdrawal of remaining charges on conviction on one of several charges. Section 224 informs us when a charge containing more heads than one is framed against the same person. Okay, when there are more than one charges against the same person, the section further says, and when a conviction has been had on one or more of them, which means there can be a situation when a person is charged under many sections, but on conviction, he is charged only for one of the charges made from many charges, or more of them means maybe 2 or 3, but not for all of the charges. So in such a situation, the complainant or the officer conducting the prosecution, which is the public prosecutor, may, with the consent of the court, means obviously you have to take the permission of the court, withdraw the remaining charge or charges. So the charges which are not proved can be dropped, and there is an option to the court as well if the complainant or the officer conducting the prosecution, which the public prosecutor, does not proceed to ask to withdraw the charges, then the court of its own accord may stay the inquiry into or trial of such charge or charges, which means the court on its own motion as well can stop the inquiry and the trial because the offense has not been proved for such charges which were framed with all the other charges. And the section further informs us that it is very obvious such withdrawal shall have the effect of an acquittal. Definitely, when the charges has been withdrawn, the person is acquitted for such charges, unless the conviction be set aside, which means that if the court does not set aside the conviction, the court may proceed with the inquiry into or trial of the charge or charges so withdrawn. So it is the discretion of the court whether to stop the inquiry or trial in the charges so dropped or not. That's it.